Moving on is the adoption of a resolution. Thank you, staff. I appreciate your time. The resolution of intent to initiate a transition to district elections. City Attorney McDougall, will you please introduce the special counsel presenting the report?
Yes, Mr. Mayor, and gladly this evening we're joined by Marguerite Leoni of Nielsen, Merksamer, Parrinello, Gross, and Leoni. She is an expert in districting, redistricting. She has been retained by the city to assist us with California Voting Rights Act issues, and she is here this evening to present the presentation on this matter.
Thank you, City Attorney, and good evening, Mayor Anthony and Vice Mayor Schultz and council members. Thank you for the invitation, and I'm pleased to be here. We have a PowerPoint here, and there we go. So the California Voting Rights Act is a special civil rights law of the state of California. It differs from federal law in significant ways, and it applies to the city of Burbank as it applies to all cities in California that have at-large elections. And why are we talking about this tonight? And it'll be a little bit later in the presentation. But the reason is because the city has received a notice asserting that it is in violation of the California Voting Rights Act. So a little bit of education is in order, and talk about options for a path forward. So what is it? California Voting Rights Act is in the California Elections Code. It prohibits at-large elections. So if your city is in districts, in the sense that it conducts elections within districts and not citywide, that city is not subject to the California Voting Rights Act. It's subject to the federal act, but not the California Act. So it applies to at-large systems. As we all know from last November's election, Burbank has an at-large system. It also expressly applies to charter cities. It is in the language of the statute. Generally, charter cities have authority over their own electoral systems. In this particular instance, the state of California has deemed it appropriate to include charter cities in the California Voter Rights Act. In federal law, the Voting Rights Act applies most forcefully, not exclusively, but most forcefully when there is an ability to create a majority-minority district within the city. Under the California Act, that is a consideration, but it's only a consideration at the remedial stage of litigation. So you go all the way through the liability phase before you ever look at remedies. So it's a very different litigation procedural picture than in the under the federal act. So let's get some basic information here about Burbank so we understand what we're talking about with some facts on the ground. Number one, 2010 census. Now, if you pull up the census website and look at the numbers, you're not going to see these exact numbers about the city of Burbank. That's because California law requires the census numbers to be adjusted for prisoners. And prisoners are not counted in the census unless they can be reallocated back to their last known address. So everybody in prison that used to live in Burbank is pulled out, and those whose last known address was in Burbank get put back. So the numbers are somewhat different. Not drastically so, but they will be different. So based on the adjusted census numbers, the population of the city, just over, close to 108,000 people, 107,614, and about a quarter of that population is Latino. The Asian percent is significant as well, 13.45%. But from the consideration of voting rights, the law looks at people that can vote. And so those are your citizen voting age population, and the popular acronym for that, we all have acronyms, is CVAP, CVAP. And in City of Burbank, the Latino CVAP's about a fifth, a little bit over, 21.69%. The Asian CVAP, citizen voting age population, just about 11%. So we do have significant minorities in the city, but we also have a significant history and a commendable history of election of persons, primarily of Latino background, to the city council. In fact, I look back, and since 2003, there's always been one or two members on the council of Latino or Hispanic background. Currently, we have 2 members of color on the council. So this is a significant credit to the city over time. So now I mentioned that letter that we received. We received it in August. That's a prelude to litigation. There's no other reason to send you that letter. And so I want to talk a little bit about what that litigation looks like. What do the plaintiffs have to prove? Number one, they have to prove that they sent you a letter, a certified letter. They can't sue you without sending you that letter. So that's a check off the litigation checklist. We got that letter in August 2022 from a LA law firm, Radcliffe and Mays. You have to have an at-large system. We've established that Burbank does. Plaintiffs are asserting that there's racially polarized voting in the city. Now, I said a very positive thing about your city and the ability of Latinos to get elected. But what racially polarized voting looks at is whether that Latino is actually the chosen candidate of Latino voters. So it's a little bit of a deeper analysis, a different analysis. And the plaintiffs have asserted that that standard is met. The fourth element that they need to prove is impairment. In other words, because of the racial polarization, has that defeated opportunities for Latinos, Asians, other minorities to be elected? For example, there can be racially polarized voting and the Latino choice prevails nonetheless because there's significant crossover voting. So there has to be really an impairment of voting rights. Once again, for the election of minorities, Burbank has a positive history, and that would come to bear in favor of the city in litigation. But I think a significant thing to know about litigation is, unlike other types of litigation, when you win the lawsuit, you win the issue for once and all. Not in the California Voting Rights Act. It's a continuing obligation and a continuing violation if it is not remedied. So winning a lawsuit doesn't protect you from the next. CVRA litigation, on top of it all, is quite expensive. It's expert heavy, it's witness heavy. Experts are quite expensive. Each side will have 3 or 4, and the litigation generally goes on 10 days. In Santa Monica was 6 weeks. The demand for attorney's fees for 6 weeks of trial, and not the appeal in Santa Monica, that hasn't come in yet, is $22 million. There were 4 attorneys on both sides, high-paid law firms, numerous experts. It was a grueling trial. That includes an enhancement. The payment of attorney's fees to plaintiff's counsel in a California Voting Rights Act case is obligatory. It's only if the case is frivolous that you would not need to pay. And if the city won that won that litigation, it would not be entitled to its fees, and it would not even be able to recover its costs. It's a very dramatic tilt in favor of plaintiffs. Getting away from litigation and looking a little bit at process. State law sets forth a process. It's a bare bones. It's minimum. The city can enhance it. It cannot reduce it. The basic process requires a minimum of 5 public hearings. The first 2, you're on a listening tour. What does the public have to say about community, about the shapes of districts, about the items that ought to concern the council when it comes to the design of these districts? After the listening tour, there's a period of time where maps are developed. Generally, this council will facilitate the submission of maps by members of the public, but typically, the council will also have a consultant to assist with the design of maps by amalgamating all of the public comment that you hear. Maps are published, and then you go into a second round of public hearings. Needs to be a minimum of 2. Both sets of public hearings are timed. You can have workshops in addition. You can add to the public hearings, feeling you need to hear more from your community, need to hear more from your consultant, but you cannot ratchet it back from 2. Everybody comes up with a plan everybody loves. You still need your 2 planned public hearings. And then there is a final phase, which is map adoption and implementation. Going on to the next slide, is voter approval necessary? As we all know, Burbank's a charter city. And your charter says that your elections are at large. There's 2 problematic words in the charter. State law has implemented a streamlined method for addressing the charter requirement. State law has preempted all other laws, and your charter is considered a law of the state of California. It's in the California law books. There's uncodified laws, which are the city charters, and it has the same stature of law. And what this provision says is that not regarding any other law, in order to comply with the California Voting Rights Act, this council can change your election system by ordinance. So to comply with the Voting Rights Act, you would want to institute fairly designed districts. That would be a method of compliance. And that would arguably be within this exemption and allow you to proceed by ordinance as the first step. Of course, eventually you have to bring your charter into compliance. So down the line, there is going to have to be a language change in the charter. But the first step can be accomplished by ordinance and without voter approval. Those are very bare bones of a complicated law that's been on the books for over 20 years now, 2001, 2002. Seems impossible. There was a lot of initial litigation, was kind of on hold there for a while, but it's up and active right now. It's before you because of the letter you received. And I just want to get some basics out to you on what the law provides and your options. We talked about litigation. What is before you tonight on the agenda is a second option. I hear discussion up here about liking options, and that's a resolution of intent. And the importance and the benefit of the resolution of intent is it is the first step in the process, but it brings a benefit along with it as well. And that's a 90-day protection to allow you to work on your districts and work within the process without getting sued. If you pass this resolution of intent, then nobody can sue you for at least 3 months. It's possible that that protection against litigation can be extended. There are terms and conditions for that, but it's not all a one-way process here where you're working with the plaintiffs on your heels. No, There will be protection for you to work with the community and not worry about litigants. Anything else, City Attorney, you'd like me to address at this time?
I think that covers it.
Questions?
We'll get to questions, I'm sure.
Okay. Thank you.
Thank you, Ms. Leoni. Public comment. We have Mr. Schlossman.
Who else? It's a new record. Boy, I'll tell you, everybody who lives in these new districts, their utilities just went up 100%, not 50%, not 8%, 100%, because all these people in these districts, you know, they're going to have to, in addition to these bonds, you're going to have costs of living for the employees and need new trucks and blah, blah, blah. So think about what you just did. It's not 8%. Okay, look at, this thing is here, districting. It's real. You can't get out of it. I'm in favor of it, and I asked to be the plaintiff for both here and the school district, but I'm not ethnic enough. That's what they told me. So it's true. That's what they said. So this is a fight you can't win. You can't fight this. You have to vote for it. It's a big deal, and it's complicated. And I suggest that you folks get with the school district and partner with them on the education in very plain language of what's going to happen. The school district is already talking about increasing the number of board members. And I suggest that you folks talk about it here too, that we increase the number of council members. So this is a big deal. You're going to have to move forward with it. There's no choice. It's too much. It's a fight you can't win, just like what I said. So it's here. Thank you for your time.
Thank you, Mr.
I'll be
Schlossman.
back one more time.
Ms. Leoni, just a couple of questions raised by the commenter. You said that the Voting Rights Act says, notwithstanding Section 3487 or any other law, we can pass by ordinance the requirement to be district over at large, but does it also allow for us by ordinance to increase the number of council members?
It does not. It doesn't address that expressly, but the criteria is to bring you into compliance with the Voting Rights Act. And what brings you into compliance is the districts. Your charter addresses several things: at large, 5 members, rotating mayor. 7 members, 5 members makes no difference to the Voting Rights Act. Elected mayor, non-elected mayor makes no difference. So this resolution doesn't limit you from considering that. It's just if you go in that direction, 6-1, 7-1, you don't get the benefit of this statute. You then do need to bring it to your voters for approval of a charter amendment.
Before we can do anything else?
Yes.
Gotcha.
All right. The other way to handle it is to step it. Do your districts, get them in place, roll them in. It's a transition type thing. Nobody is cut out of office. Everybody keeps their seats as elected. It transitions transitions over 4 years, and during that period of time, discussion can be had about council size and the benefits of the directly elected mayor in a districting system. Does that make sense for this city? Nothing prohibits you from considering that in the future.
Okay. Let me ask you this. There was a discussion for a long time to get a directly elected mayor. The process by which we select our mayor, that's not in the charter, right?
I believe, and of course I'll defer here to the city attorney, I believe that the charter says you have 5 council members, right?
Yeah.
And I thought the mayor is selected from among the council.
Right. And we do that just by, we actually don't have an ordinance on that, right? It's just practice. All right. Well, interesting. So let me ask you this then. It says we can go from at-large to districts without having to deal with anything else. But in it, does it allow for 4 district council members and 1 at-large council member?
If you're,
See where I'm going with that?
yeah, I see where you're going with it.
And then we choose who becomes the mayor, and we say
Let
the
me
one
tell
who
you
got
what
the at-large
California
seat.
Voting Rights Act says. The statute that we're looking at that allows you to change it by ordinance, unless you have a provision here in the charter that prevents it, would allow you to go to 4-1. However.
4 districts, 1 at-large.
Yeah. The ordinance that I'm talking about right now, 34886. Now, if that council, that at-large member is just another council member and not a directly elected mayor with different authority, then arguably that's an at-large feature in a districting system. And the law describes at-large as what you're doing now. If you have residency districts where you all live in a particular district, but get voted on at large, that's considered at large. But also systems that have, quote, the ambiguous at-large features. Arguably, a charter city can have a mixed system.
Oh.
But arguably, that's an at-large feature under the CVRA. However, on the other hand, if you have an office of mayor that is defined and directly elected, that's permissible under 34886. What's the difference? Generally, an elected mayor has different authority and different responsibilities. It can also have a different term length. There are some mayors that are elected every 2 years.
Right.
So the voters have the opportunity of making a sea change on the council every 2 years. Kind of an interesting system. Tough on the mayor, he's always running.
Okay. Well, great, thank you. Councilmember Tarkovsky.
Yeah, follow up on that.
Let me supplement the answer. Charter Section 400 provides that at the reorganization meeting, the new members shall then be inducted into the office, which just happened, whereupon the council, as thus newly constituted, shall choose one of their members to serve as the mayor. So it really is kind of bound together.
Yes.
The details of who they pick isn't in here, but it still provides that first you have to be elected a council member, and then the council chooses the mayor. So there's not a provision for the voters to separately elect the mayor, in which case we would have a charter conflict that's more complicated than as Ms.
Gotcha.
Leoni described.
Okay.
So follow-up question to what Mayor Anthony was leading to. So is it possible to have an at-large mayor that doesn't have any more responsibility or power than any of the council members? I think Riverside does something like this.
And so does Oakland.
Okay.
Oakland has a mayor and 1 at-large council members, but I think Oakland's council is maybe 10 or 11. And I think there's another California city that has an at-large feature. It might be, it's farther south. It's south of the city of Los Angeles. Paramount, is it Paramount maybe? Has a at-large mayor. I can't tell you you'd be safe if you do that. That would arguably leave the city vulnerable because you just have one floating council member. And that seat would be arguably more difficult in a racially polarized city. A racially polarized vote, it would be more difficult to be accessed by minority.
Because it goes back to the at-large
Yeah,
problem.
goes back to
Right.
the at-large problem.
And the charter does specify duties for the mayor. So again, you'd need a charter amendment to change those duties if they weren't going to be as currently specified.
Right, okay. So how does Riverside and the other city that does it this way, are they at risk?
They're at risk, but they
Okay.
haven't been sued.
Uh-huh.
Yeah, they're at risk, but they haven't been sued. That's the law. It has an
But their charter
at-large
already has
component.
the mayor in it, though.
Excuse me?
Their charter already has a mayor
Well,
in
then
it.
they're fine. They have a mayor in the charter. That's a separate office.
Right.
It's like the president.
Right,
It doesn't necessarily have to be a strong mayor.
right.
Right. It's
So-
just a person, a separate office.
Yeah.
It's separate from council member, has separate duties. They're often ceremonial. They often have to do with the agenda. They often have to do with emergency services and emergency responsibilities. Cities that I know of that have separately directly elected mayors have a whole section in the code about what the mayor
Got it.
does.
Got it.
And
Okay.
the compensation is
Yeah, we don't have
often
that.
larger for the mayor.
Got it. Okay.
It's a different office, but a strong mayor does not sit on the council.
Got it. Okay.
Most mayors do sit on the council, but they have different responsibilities in addition to council.
Okay.
Yeah,
Got
okay.
it. Makes sense.
That was essentially going to be my question. As long as the responsibilities are distinct,
Yes.
then we are not subject to the at-large
And I'll
risk.
point out a significant case on that. The biggest case to hit until Santa Monica was Palmdale, city of Palmdale, okay? City of Palmdale was defeated after a 10-day trial, but at the remedial stage, the same judge that held that their system of at-large elections violated the California Voting Rights Act allowed them to keep their separately elected mayor and said this mayor has special duties. It's a tradition in the city. This is how this city operates. We see no problem with it. So after all of this trial, $3.5 million paid to the plaintiff, Palmdale kept its directly elected mayor. It's a little bit, yes, it's elected at large, but the real term in code is directly elected mayor. That is not selected by council, it's elected. And even in Palmdale, they were able to maintain their mayor.
And follow-up question to that, does that mayor sit on the council?
Yes. Not a strong mayor. Who's got strong mayors? San Francisco, Oakland has a strong mayor. Obviously, LA has a, yeah. These are, a strong mayor does not sit on the council.
Yeah, they're the executive of the
They're
city.
the executive, yeah, and they generally have a veto power. And then there's, yeah.
Jesse,
Don't
you
get
want to
any
be, you want to be
ideas.
mayor? It says-
Second that.
Okay, so basically, we're bound by not only what's already in the charter, but tradition.
Yes,
So we just can't like, oh, a new lawsuit, let's change things up real quick. We would have to go to a charter to change
yes.
that drastically.
Yes,
Okay.
completely, and get the voters' approval for that.
Okay, okay.
Takes some thought.
Mr. Vice Mayor?
Yeah, so I want to zoom out just a little bit. I want to pose a hypothetical to you.
Oh, good.
Let's say, I know everyone's law school favorite, right? Let's say that this council decided that we adopt the resolution tonight. So I guess I'll break it up into a couple questions.
She bills us by the minute, you know that, right?
I know.
Okay.
So if we adopt the resolution tonight, these unanswered questions about the size of the council, whether to have, I think you're referring to it as a weak mayor, these are questions that could be answered at what stage of the process? Would it be the public hearing, the final hearing of adoption? When would it be?
They could be addressed all along the way. The implications of addressing them is you may end up needing a charter amendment and not be able to do this yourself. But if you look at this resolution that's before you, it says nothing about the number of districts you're going to do. And it's not a word in there. It says, we are going to go through the process. Now, it does reference 34886, which may have an implication in it that you're going to go to 5 by-district elections. But there's no reason you can't change that. You get an overwhelming support in your community for an increase to 7. You're not precluded from considering that.
So follow up to that, here's the hypothetical part. What if this council were to say, we'll adopt this resolution, we go through the process, and we go to, for the sake of expediency, within 90 days or 180 days, we go to districts for the 5 seats. Now, is there anything that would stop this council after that point from, let's say, doing a special election in the primary of 2024 if we wanted to make additional charter changes? For example, you know what, we're going to have 7 seats. We're going to have the weak mayor. I'm assuming nothing would stop us from doing that.
Nothing.
Now, the only problem that I see with that, and I'm wondering if you have any comment on it, is we're about to go through a process of drawing maps. So you don't really want to duplicate the effort. So could, in theory, in drawing the maps, we draw two sets of maps. One that contemplates 5 district seats, but at the same time adopt maps that would contemplate, say, 7 seats.
Yes, you could do that.
Or 4 and 1.
Or 4 and 1, or the point is we
You can
could.
ask your consultant, not only for your edification, but for the edification of the public, to take a look at these options. Now, you're going to get stronger minority districts with a greater number of districts. You're going to have smaller areas concentrating your population. Your Latino and your Asian population is fairly dispersed throughout the city. You don't have an area that you just say, this is the Latino area. It's unlike a number of other cities that I've worked with. And the smaller, your districts have to be equal population. You take that 107,000 divided by 5, you're going to get one number, what is going to be 20,000 or something, but you make that smaller, it boosts the strength of a minority group or a community. Let's not talk only race. It enhances the influence of communities within those districts. So that may be part of the educational process for your community, as well as for you.
So I appreciate the explanation. I have 2 final questions, one for you, and then I think one that'll maybe be better addressed to our city attorney. So my question to you is, as we go through this process, and please correct me if I'm wrong, we could draw maps that contemplate, let's just say for the sake of the hypothetical, we contemplate 5 districts and we implement that immediately to address the lawsuit. But through that public input process, we could develop maps that would contemplate a 4 and 1 with a weak mayor, or maybe 7 seats. Could we then, say, in the primary of 2024, have that special, and if it's approved by the voters in a charter amendment, we could implement those changes in November of '24?
Yes, and you would be protected. The fallback would be 5 districts.
If it failed to pass.
If it fails, the fallback is 5 because you have done that, and you have protected the city, you've complied with the California Voting Rights Act. But then you say, look, this is what we're going to do, and put it to your voters whether they prefer a different system. And so your ballot measure would obviously repeal what you did before, but bring into effect your 7-1, your 6-1, your 7-0, your 4-1 system.
Thank you very much. I personally have really enjoyed the thought exercise. I find it all very fascinating. Mr. City Attorney, here's my final question. Now, for purposes of our action tonight, we have a resolution, and attached to the resolution is attachment A, which is a tentative schedule. At the bottom of attachment A, for the schedule, it talks about in November of '24 electing 3 district seats. So I just want to confirm that wouldn't prohibit us from going through this process I've just discussed with Ms. Leoni, right? Of going through the charter amendment at a later point, and if approved by the voters, having 4 and 1 or 7 seats or any iteration of that.
Right, so this schedule at the bottom of Exhibit A, which is page 5 of the resolution, it actually has, for November 2024, 2 seats, which are the mayor and vice mayor's seats, which are up in 2024. And then November 2026, it says 3 new districts, which would be the new council member seats. So it presumes that transition based upon the current term. But as you've already asked Ms. Leoni, should the council come up with an alternative phase-in program, or which cuts terms short and replaces everybody, or expands the number of seats or any variation thereof, and it passes at a charter election, then you would beat the clock and you'd have something new by 2024 or 2026.
There's a number of ways to roll in new seats, and charter cities have lots of options for doing that. As the city attorney said, you could have everybody cut all terms short, we're starting fresh. That's one way to do it, but you can also phase in seats by implementing short terms. And they're drawn randomly. You get your say you're going to 7. You get your 3 new guys up in 22, and draw straws for the short terms and restagger. Somebody runs in 24 and somebody runs again in 26. Orange just did it that way. City of Orange in Orange County went from 5 to 6 and the mayor. And we rolled them in with a short term.
And thank you both for that answer. And I misspoke, Mr. Mayor. I did think of one, I think, important follow-up question. Mr. City Attorney, assuming that we wanted to look through I'm trying to frame the question in a way that fits within the Brown Act. Assuming that we go through this process and we look at alternative designs, 4-in-1, 7 seats, to the extent that it would entail a future charter amendment, to what extent would we have to involve our charter review committee in that process? What would they need to do versus what we could do as part of this public process?
So the council can define any process it wants. I mean, the council can initiate an off-cycle charter amendment. You have to come up with something to put before the voters, and you have to find an election cycle or pay for some other cycle. So we have to make sure we match the elections code. But the process that we're in now is simply the default process on a 5-year review, citizen committee that then council appointed the citizen committee, who are all willing participants, to the charter review committee, and they're only considering 2 or 3 issues that came out of that review. But nothing prevents the council from initiating some other form of charter review should they wish to. In fact, the process we used to have had no charter review. So the 5-year was created, and your committee this time, because you have a member who was on the last charter review, said this isn't very fruitful to look at it off election cycle every 5 years. So one of their recommendations is do it 8 years and start it soon enough to have the issue come up that matches election cycles. But the council could initiate an amendment in any other manner it chose.
And just for my money, I'd rather do it that way because, if I remember correctly, our charter review discussed districts, and they were not interested in taking it up. They felt it was much more an appetite for us to deal with. Like you said, there's a couple issues that they were very much looking forward to. So I think we can handle it up here.
Well, more importantly, if you look at the schedule that Ms. Leoni put together for us is designed to keep us in the safe harbor of the elections code. It having participated in the charter review process and given the amount of public outreach, I don't believe our charter review process is equipped to meet these timelines and give the council a voice. So more directly, this process is intended to work directly with the council so that there's not a whole separate 90 days to spool up the council and do yet more outreach.
Okay.
Follow-up question from that then. So, but there are other decisions that the Charter Review Committee might be working on that would be impacted by this decision tonight. So they're going to be informed at least of what's happening here, so that they can maybe consider that information when they're talking about like term limits, for example.
Theoretically, it could. Having been through that process, I think they could do their work independently. Some of their opinions, this came out in public testimony before the council, some of them wanted to abandon the term limits just based upon the change in council. But I think a longer-term view is, what is the merit of term limits? And I think the merit of term limits is still valid, whether it's 5 members or 7 members. And the term limits were not just for the elected council. Some of them wish to explore term limits for board and commission members or specific to a board or commission. So all of that work can still be done. Their outcome doesn't change the charter either. That still has to come to the council for the council to determine a time when that could go before the voters if the council wished to push that forward.
I have one more.
Yeah.
And then back to the discussion of when we have the election or when we have the charter amendment up on the ballot. If we do it ourselves on an off time, it's more expensive to run the election because we have to basically run an entire ballot election on our own. But if we do it.
You mean as a special election?
Yeah, a special election.
Okay.
Right, yeah.
Not in the primary or the general?
Exactly.
Gotcha.
But if we align it with one of the primaries or general, then we can bring it in with the rest of the election process. And since we've aligned our elections with the federal elections, would then the county take care of the charter amendment, or would we still be responsible for the charter amendment here?
We consolidate for administration of the election. We still have to do our local work to turn our ballot information into the county. So that's just the administration of the election, the counting of the votes.
Okay.
I imagine we would be on our own if we did our own special that wasn't on with the county. I will say, though, I don't have the slide number in front of me, but there's a slide in your slide deck that talks about how much legal fees all the cities paid. A special election on our own is less than any city paid in attorney's fees. So if you look at comparatively, if the council wanted to do something more dramatic, it's still less to do a charter amendment and achieve your objectives than it is to try to go for a period of time without complying with the California Voting Rights Act.
Great. Okay. Thank you. That's all I got.
Response.
So my question is, and I think the question is being asked from the public who read the report and wondering, number one is with the concern of why can't the voters, or would we take this out to the voters to decide for themselves? And if we do, let's say they turn it down, the question was, would you still get sued? I know the answer to it, but I think it's important. Similar to what happened to the city of Glendale, they went out to the voters turned it down. I shouldn't say this out loud. They've been lucky that nobody went after them. But
Why don't we use the city of Escondido?
yeah, so if you can touch on this
Yes,
issue,
let me
because
touch
I
upon
think
that.
it's important that the voters understand that.
Yeah, no, and I want to just mention Escondido because it does present that fact patterns with a lot of other little things going on in Escondido. But they did place the question, it's Charter City, and they placed the question of by district elections on the ballot as a charter amendment. They had actually been sued already, and it was part of the settlement that they would be able to put it on the ballot. Well, of course, it was turned down, and that didn't protect them from subsequent litigation activity, which was a court-ordered plan. So I think the takeaways are, it may be politically expedient for you not to take the hit and to put it on the ballot. But if the voters turn it down, it doesn't provide any protection for the city. You can still be sued. It matters not what the voters say.
Thank you. The other question I have, and it's more of an explanation so the public can hear you, and your opinion on it as well for us. Having the school district going through it right now, and the conversation that came up in regards to like team up with the school district and see if we can work on it together, more informative to the public, and then maybe cut costs. What is your opinion in regards to teaming up with the school district that we may not have the same interests in the locations?
Well, it was interesting. There may be some savings that can be realized there with the creation of database. I don't know where that can happen, so the opportunities are there. But listening to the school district meeting a couple of weeks ago. I didn't listen to the most recent one. I think they kicked off maybe last week. But the week before, I listened, or 2 weeks before, while they were doing their resolution of intent. And they really view their interests as quite different from those of the city. You do different things. Typically, a school district will want to look at attendance areas, but not for keeping them together, but for dividing them up, so that people in an attendance area have more than one board member to refer to for a problem, and so that the board doesn't become tied into a single community and a single school. That district educates, and they will focus on school facilities, attendance areas, closing schools, transportation patterns. Those considerations are going to be different from what you're doing as council members. You're going to look at your historical neighborhoods. You're going to look at your land use plan. You're going to look at where your development is going in. You're going to look at underserved areas, perhaps with regard to utilities. How do we bring those interests together? And you're going to be looking at municipal interests and how they should be combined in districts or perhaps separated. And they're just different considerations. Now, I will give you that there are some cities where the school districts are so important that they will form the communities of interest at all levels, and there will be overlap. For example, the school isn't in charge of traffic patterns, and traffic patterns will certainly impact safety of the schools. And I've seen that in processes where a school group will come and speak to the city on those issues. But generally, I don't believe your school district wants to be bound by what you do. And I don't think you should be feel to be bound by what they do.
I would like to supplement that by saying we do, however, we've made a recommendation in the staff report to use the same demographics corporation, National Demographics Corporation, that the city has already retained. They're a local company
That
in
the
the
school
city
district has already retained.
Yes, did I say that?
Yeah.
Yes, that's what I meant. That the school district has already retained, so they're already familiar with Burbank. They're a local corporation with offices in Glendale. They understand that there are...
You guys got to stop saying Glendale. We're going to get them in trouble. Just kidding.
It's a local organization. They understand the necessity that we may have some necessity for confidentiality. And so they're prepared to have different project managers, but they will look, they've pledged to look for opportunities to save costs where possible.
I like that.
And so at least they'll have the experience of already kicking off the process. They've already had their first public hearing, I believe, so that we should benefit at least from the momentum, and it gives us the opportunity to collaborate where there is an opportunity, because we're going to be, this whole topic of districting is not something the city normally does. There's no staff available to carry out this effort in 90 to 180 days. So we'll be relying on them heavily to really help the council reach out to the community and get the information out and collect the information back. So that's part of our recommendation, is to collaborate where possible, and this would be the organization to help us do that.
Mr. Attorney, correct me if I'm wrong, though. The school district doesn't have a charter to conflict with, so they can just do it by ordinance, and they're out in the clear. Is that right?
Yes, we do have a low-risk approach. It's the approach we recommend under this elections code provision, that we can clean up our charter later.
Sure.
But
the school district doesn't have to do that, right? So.
That's correct.
Yeah.
So their
Don't have to
guys,
do that.
so if we go in with the same team, is what I'm saying, that team is going to be done with the school district really early on.
Well, they don't do the charter amendment. We're
Right.
still responsible for our charter amendment.
Yeah. Okay.
They do the elections code process, the 5 public hearings, plus all the supplemental workshops that the council's going to want to make sure the community voice is heard.
Okay.
The charter amendment, they're not the expert in our charter.
Oh, so we would have to retain somebody else.
Well, we would do our own charter amendment,
Oh, okay.
and Marguerite would help us with making sure that we're consistent with the California Voting Rights Act. We would still do our own charter amendment.
Okay.
They may help us with the language, Marguerite would help us with the language, and then we would call our election. The most cost-effective would be consolidating with the county at an appropriate primary or November cycle. And so that would be our decision, and we would be responsible for pulling together all those legal documents.
Okay, so charter amendment we can do in-house. That's something we're able to do. But this whole mapping and that, we got to go out. Okay. Mr. Vice Mayor, you want to?
Yeah, thank you, Mr. Mayor. I just had one final question, and I think, again, I think it's to our city attorney, but Ms. Leoni, if you have an answer, I'd appreciate it. I think related to all of this is the idea of what are we going to, so we're going to have our maps now, but we're going to have a process in place which is not currently codified for redistricting every 10 years
Yes.
after the census. So if it's not through this process, would that be something, for example, we would refer to charter review? Is that something we would need to agendize separately? Because as a resident, that's something I'd want to know. I don't know if I would want 5 politicians drawing the lines.
Correct. State law, the default is you, unless the charter says something else. State law allows you to do your own districts. State law, what doesn't even encourage, it gives you the opportunity to use various levels of charter commissions. So you can have an advisory commission, you can have a semi-consulting, semi-permanent, or semi-final decision-making commission where the commission brings you back 3 options. You got to take one of them. Okay, you can't tinker with them, or you can give the job entirely to a commission.
Ms. Leoni, is this something that we could delegate from the charter to ordinance so that the charter specifies the redistricting process in ordinance?
Absolutely, that's how I generally do it.
Okay, in which case, in order to change that, the council has to do it in these chambers, first and second reading, so at least there's a check and balance.
Right.
That that process can be adopted, modified more easily than having to go through an election and pick an election and potentially have a delayed effective date.
Yes,
So that's an option.
that is an option.
Okay. Oh, yes, Mullins.
So, question in regards to the timeline when we need to discuss, for example, do we go out to the voters to put this on the ballot and have the voters decide whether we should or shouldn't become district? In the timeline of looking at what we have before us, the second reading or the 90 days is April 25th, 2023. When can we as council have that discussion and have an input from the discussion? What is our next
you wanna
step?
do. The date on your calendar is the safe harbor protection from litigation. All right. It doesn't limit you to that time. You would be wise to act within it or within an agreed extension. But if you're talking, but that's for the low-risk approach. Do our 5 districts, like get those in place. The charter, the reshaping the council, the governance, and getting your charter amendment together can take a longer time. If you want to have it on your March, think about mid-December being your deadline for getting that done, and probably backing it up to get some reports done. And so late fall would be your deadlines begin to fall for a ballot measure in March.
And you're speaking of 2024, and I
I'm
believe the
speaking of
question was 2023.
Correct.
Which means it's too late.
Excuse me, I am so sorry.
That's okay. And let me clarify the question. There's 2 parts of it.
All right.
One is assuming everybody's in agreement that we're going to move forward and have a discussion that we have 5 districts and go out to the voters to decide whether we should go from at-large to district election. Can the council have this discussion anytime during the process, during the 90 days? So we can all have the consensus what we want to do, whether we just pass the ordinance and we do it ourselves, or we go out to the voters and have them decide whether we should or shouldn't go to district.
You can
from
have that
at-large.
discussion simultaneously.
Okay.
But I want to make something very clear. You cannot have an election in '23. The legislature has taken that ability away from you. You have to consolidate your charter amendment elections with a statewide, and certain charter amendments have to be November. This one can be March. Now, it's called a special municipal election because you ordinarily don't have municipal elections in March. It's called a special, but that is the date that's specified in the elections code. If I understand your question, Councilmember Mullins, it's can we be talking about it at the same time? It depends on your capacity to develop that at the same time you're trying to meet your deadlines for the safe harbor.
Thank you. Because we can definitely, once we make that decision, if we're going out to the voters, we can do it in the March election.
Yeah.
It's still going to be called a special election because that's not a normal cycle. But this would also can take us to change of a charter in the November election when we have our final, when we have our regular
Yes.
2024 election.
Do I understand you can vote on it in March?
March,
Let's say you do
yes.
this April, let's say you do your 5 districts. You have that discussion, you come to consensus among yourselves and your community. You decide to put a measure on the ballot in March. The measure in March amends your charter, however you want to amend it. It repeals what you did in April. You're still safe because you're in districts, and you use the charter-based system in November.
I think what we're saying is there is no low-risk way to push the whole decision to an election.
Right.
Right.
Because it'll be a year.
Yeah.
So we won't be done with the process in time. In fact, I think we've already missed all the deadlines to do anything in 2023. So 2023 is not possible. So we're talking 2024. Our safe harbor runs out in 90 days or 180 days. So by midsummer, it's no longer a low-risk approach.
So we do it by ordinance and then clean it up on the back end with the charter amendment.
Clean it up or change.
Or change.
Yep.
Yeah, okay. All right. I have a question. If I personally don't want to go to 7, but I want to go 4-1, when would I have an opportunity, and this is as a voter, when would I have an opportunity to voice that concern? Would it be at these upcoming outreach meetings?
Yes, I think so. In the public hearings, absolutely.
Great. Okay, great. Or vice versa. Okay. Thank you very much. You have been a pleasure. Bring her
As have
back
you.
whenever you can.
Thank you. Thank you.
Okay, great. Anyone, I'm open to entertain a motion, yes? Ms. Takahashi?
Is there any further discussion or? Okay. Yeah, I'd like to make the motion to adopt a resolution of the council of the city of Burbank declaring its intent to initiate procedures for a transition from at-large to district-based council member elections pursuant to Elections Code Section 10010 and Government Code Section 34886, authorizing the city attorney to hire National Demographics Corporation and approving a tentative timeline for conducting public hearings, formulating proposed district maps, and presenting a draft ordinance to council for decision.
Second.
Moved by Takahashi, seconded by Schultz. Madam City Clerk?
Councilmember Mullins,
Yes.
Councilmember Perez,
Yes.
Councilmember Takahashi,
Yes.
Vice Mayor Schultz,
Yes.
and Mayor Anthony.
Yes.
Thank you.
Thank you, Ms. Leoni. I appreciate your time.